Perfect. Okay, good afternoon. Thank you for inviting me and for making the room available and agreeing to listen to the paper towards the end of the year. And I know for many of you it's the end of the academic year too, so hopefully it's worthwhile. Okay, one thing, if you're in the room or online and you have a question while I speak, just stop me, put your hand up or something. And I'm sorry, I'm getting old, so sometimes I wear my glasses to see you, but if I need to read my slides, I'm going to take them off. So, but just really do stop me, because it's more for you to make sure that you understand what I want to say rather than for me to run through 20 slides as quickly as possible. So don't hesitate to interrupt. And online, if you can't hear or something, just tell us if there's an issue. What I'm going to do today is talk to you about what has happened in the last 20 years of EU competition law with regards to abuse of dominant position. So the first major project to reform Article 102 began in 2005 and ended in 2008. I participated at that time by writing a comment on the Commission's position that it had taken in the review, and there was a big conference in London in 2005 that debated this. So I was in the center of it the first time a reform effort was begun. And I have to say, I'm a little bit tired of the fact that the Commission now, again, with a new bunch of people that were not present in 2005, has restarted the process of reform. And I'll hope to show you why I'm not so sure it's very useful. But what I'm going to do is going to start by taking you through what happened in 2005 to 2008 and why DG Competition felt it was necessary to take a step to modify its approach to applying this provision. So essentially, there are two criticisms that I put on the slide. One was the Commission was criticized for its decisions being very formal, and risk of over-enforcement, so type 1 errors. Too many things were caught that shouldn't be caught. Too many lawful business practices were declared unlawful. And the result was a very strange document called Guidance on Enforcement Priorities in Applying Article 102 to Exclusionary Conduct. Now, the title is strange. So if you're familiar with EU law, you will know that normally the Commission writes guidelines, not guidance on enforcement priorities. So usually guidelines are a restatement of the law as the Commission understands them. Now, the Commission has the power to issue guidelines in two situations. One is when the legislation requires that the Commission writes guidelines. So in merger control, when the merger regulation was rewritten in 2004, one of the recitals says the Commission shall write guidelines to clarify the scope of application. And so then you have a legal base for the guidelines. In Article 101, in agreements context, the Commission chose by itself to write guidelines for the purposes of clarifying its interpretation of the rules after it has had some experience in running cases on 101. It says, okay, rather than asking the public to read all the cases, we provide a restatement of them in guidelines. And in procedural law, the Commission writes guidelines as a way of ensuring its legitimacy. So the guidelines are a commitment to a particular way of proceeding, and then it is bound by the commitment that it makes. But there have never been any guidelines on Article 102, and one of the reasons is, if you look back, there have been very few 102 cases. So there's no legal mandate to have guidelines, and there's not enough experience to have guidelines. So it was strange when in 2005 the Commission says, let's write guidelines, because they had done maybe 25 abuse of dominance cases, whereas if you look at the 101 case law, 20,000 101 cases. So obviously, if you produce a lot of decisions on, for example, vertical restraints, so I'm just conscious, is it? Okay. It's you, sorry. Yeah, I just have a habit of looking at the chat.
The data.
So if you do a lot of cases, then it makes sense to have guidelines to consolidate. But if you do, one discount case in 1974, another discount case in 1978, and then no discount cases until 1985, there's no real need to have guidelines to explain your law, because there's just not enough. So the reason why this document came out was really more as a response to the criticism. And so the Commission said, we're going to change our approach in a fairly radical way. And the only way we can communicate that radical change, because we don't do a lot of cases, is to have a soft law document that explains what the change is. What happened between then and now is the Court of Justice was then asked for its opinion on this guidance paper. And what has happened since 2012, 2017 in particular onwards, is the Court of Justice increasingly accepted the guidance paper. So the court gradually changes from the cases before to a modern approach to Article 102. So if you look at the cases, I'm going to look at one in particular in detail to show you how the court changes its mind. And this is a very unusual process because the Court of Justice, as you probably know if you read the cases, doesn't say, I am changing my mind. So it's not like the US Supreme Court. So the US Supreme Court, if they change their mind, they say, we'll overrule. And so you know the law has changed. So in 2007, when the Supreme Court decided the Legion case, they said, okay, we don't like our judgment from 1911, Dr. Miles, we're going to go back to the rule of reason, and this is what we're going to do. It's explicit in the judgment that the law has changed. In the European Court's language, it's never really clear. The court doesn't tell you we're changing the law, but they do. And so you have to look at the judgments quite carefully to do so. So the way to do it is to look at the language the court uses and to see if one word in a paragraph changes from one judgment to the other. And then you know the law has changed because they've tweaked the word. Because the way the court writes is it copies and pastes from previous judgments to the other, and that's how you know it's consistent, because it's always the same phrase. But once you see the phrase changing, then you know the law's changed, but they don't tell you explicitly. So we have lots of cases which come from two sources. One is commission decisions, and the other is preliminary rulings from national courts. In particular, the Italian court, in the last couple of years, has asked the Court of Justice some questions on the interpretation of Article 102. And these are interesting cases because the national court asks very basic questions, like, what is an abuse of a dominant position? Do you need intention? Things which are fairly clear if you actually bother to open a textbook on competition law, but the national court, which is quite an experienced court, asked these questions because they felt that something was changing in the Court of Justice. And they said, we need more clarity because we know the court is moving from A to B. And so they asked some very fundamental questions in order to actually test what is the move from A to B. And then in March 2023, this year, the Commission announced a review of Article 102 again. So this is the second time there is a reflection by the European Commission as a competition authority about what should we do with Article 1 and 2, and that's what I'd like to discuss. But I want to take you through the story in order to kind of understand why in March 2023 the Commission announces this review and what the review is about. Okay. So this is Article 102 if you don't know it. The first thing to know about this article is that everything in small print is useless, right? So I always tell my students, only one sentence in Article 102 matters, the first one. The rest is just rubbish, because the concept of abuse is not closed by the list. The list is just examples. So the court has invented its own idea of abuse of a dominant position, and the Commission also invents. And as you will see in the Super League case, the court invents another abuse that we never heard about before. So what matters is if you look at the text at the top, is it doesn't use the word competition. Abuse is prohibited when the conduct is incompatible with the internal market. That's it. That's your test for legality. Is this behavior compatible or incompatible with the internal market? So it's very open-ended. It's the same test in merger control, right? Substantial impediment of effective competition is prohibited because that conduct is incompatible with the internal market. But at least in merger control, the incompatibility with the internal market is qualified. What is incompatible? That which significantly impedes effective competition. So the test for incompatibility is translated into economic terms. Here it's not. Here it's just incompatible with the internal market. And this is because in 1956-7, when the treaty was being written, they hadn't got a clue what they wanted to do, but here is a competition rule that makes some sense to them at the time. So we have a very open-ended provision which gives the Commission and the court a lot of flexibility about what to do with it. And that's why, in a way, the provision and its interpretation are controversial, because it's very open-ended. So let me just take you very quickly through the law from 1970 to 2008. And I'll give you three abuses. So on the left-hand side, you see refusal to deal, predatory pricing, and loyalty discount. What I do in the second column is I very quickly tell you what the law was before the guidance paper. Then in the last column, I explain what the law is according to the guidance paper, and then I'll try and show you a bit the differences. So take refusal to deal. This is the easiest abuse, right? So a dominant company refuses to supply a small, medium-sized undertaking. So in continental Cannes, this was the first refusal to supply case in Europe. There was a big American corporation which refused to continue to, I just realized there's a mistake on the slide, but refused to continue to supply a small Italian company. And the court said that's an abuse of a dominant position. Why? Because you're refusing to supply, and that's it. No justification. There was no attempt by the court to say the refusal reduces total welfare, reduces consumer welfare, harms welfare in any way. No, it harms this company, which was being supplied and now is no longer being supplied. That's the abuse of a dominant position. That's it. And so you can understand why, particularly it was a US company, American commentators would be a little bit puzzled to say, what's the justification? It cannot just be that because I am a large company and I'm stopping supplies to a small company, that is an abuse of a dominant position. And yet that's all the court really says. And so this began the criticism from the US. You are protecting competitors, not competition. So you're protecting the small firm without asking, is this small firm efficient? Is this small firm's continuous existence in the market beneficial? No, you just ask, are you a dominant firm? And are you stopping to supply somebody else? Then in the 1980s, the Commission took a case against AXO for predatory pricing. And here what's important is what the Court of Justice says, not so much what the Commission says. And the court comes up with a ruling which says if price is below average variable cost, that's an abuse of a dominant position, full stop. Now, that test is interesting because it follows some of the economic literature. So if you go back to Arida Turner, they also said price below marginal cost should be an indicator of predatory pricing. But if you look at the economic literature, price below cost is only one element of predatory pricing. You also need a lot of other economic considerations than just price, but the court says that's enough. So it creates a rule which is over-inclusive. And then loyalty discounts. One of the early cases is Michelin #1. Michelin manufactures tires, and it was the most popular brand of tires in Europe at the time, but already in the 1980s it was feeling competition from US and Japanese firms. And so Michelin tried to retain its distribution system by offering discounts to garages that used Michelin tires exclusively. And the court condemns a loyalty discount simply on the basis that it induces loyalty. So the fact that the only way the dealer can get a discount is if they buy tires exclusively from Michelin is the abuse of a dominant position. Because this puts pressure on the repair shop to buy exclusively from one party rather than from others. And it discriminates among retailers because if you buy a lot of tires, you get a bigger discount than if you're a small shop and you buy fewer tires. And therefore there's secondary line price discrimination, and that's bad. Again, economists were attacking this decision left, right, and center because it took no account as to whether or not consumer welfare would be harmed. Does this conduct actually cause an increase in the price of tires for consumers because it's a discount? And the question was, well, the court doesn't ask you to test for that. So what these cases had in common was one big firm, one conduct which didn't look very nice, and some people complaining about it. And that was it. And so the problem that the academic literature had on these cases is that there was no accounting as to why these three things were actually an abuse of a dominant position. What are you trying to protect? What are you trying to achieve? Is not actually clear if you read the judgments, according to the critics. I think it's very clear, but I'll just give you the criticism. So if you compare now before the guidance with the guidance, it changes quite considerably. So refusal to deal, we have a test which is there. Product is necessary for competition. Refusal eliminates competition. There is consumer harm. And the consumer harm bit is quite important because that's nowhere in the case law. There is no abuse of a dominant position case or refusal to deal before 2008, where the court makes reference to consumer harm as a necessary element of the abuse. So the guidance paper is actually quite a revolution because it says, look, in order for us to lawfully challenge a refusal to deal as abuse of a dominant position, we need to prove necessity, elimination of competition, but also that this causes harm to consumers. Which is why the title of the guidance paper, Guidance on Enforcement Priorities, is a little bit misleading. Because it's not priority, it's actually changing the law. And this is why, when the document was sent to the legal service as guidelines, the legal service so the commission is a bureaucracy which works like this. DGs, Directorates General, write policies. They try to write these policies then in a legal text. And the legal text is then checked by different directorates general, one of which is the legal service. Every legal document goes through legal service. And the legal service was not willing to sign off a document called Guidelines on 102 because it was changing the law. And said, no, guidelines have to interpret, not change. So then they came up with this compromise title, Guidance on Enforcement Priorities. But if you read the document, it's written like guidelines. And they just basically wrote enforcement priorities later when legal service required them to do so. So this is one of the changes, for example. The other changes in predatory pricing, they use the price below average variable cost test as a starting point in the guidance paper. That's not enough. We need to ask ourselves whether there is a profit sacrifice and whether this profit sacrifice strengthens the market power of the dominant company, harming consumers. So again, it uses the predatory pricing case law as the base, but then builds on it other requirements. And then for discounts, the same thing. Yeah, discounts can be unlawful, but only if the price is below cost and the coverage of the discounts is so large that it can foreclose market access to rivals as efficient as the dominant company. So a clear theory of harm here. Do discounts foreclose market access to companies as efficient as the dominant firm? So for each of these abuses, the guidance paper changes the law radically because it adds to the existing requirements or changes them completely. So in the last one, it's a complete change. Before the guidance paper, the case law was, if the discount is based on loyalty, it's unlawful. If it's based on cost savings, it's lawful. Whereas now you have to ask a more complicated question as to whether the effect of the discount is such that the price is below cost. I'll explain this in more detail later. But the point is, all of the three converge, all the three reforms converge into saying, let's focus on consumer harm. And how does consumer harm happen in Article 102 cases? When the dominant company excludes or harms rivals so that it can then increase prices. So the Commission builds a common approach. It doesn't matter what the abuse is, the test looks for the same thing, foreclosure and consumer harm. And this is useful because these practices can be substitutable. So if you're a dominant company and you want to do practices which are forbidden, and you look at the list of what is forbidden, you can find a way of saying, okay, I'm not going to price predatorily, but I'll give a loyalty discount, which is just as bad as predatory pricing, but I will get away with it because the case law is less demanding, for example. By creating a single standard, then the dominant firm cannot shop for the most convenient practice because the law kind of allows for this, right? So there are three kind of ideas that the Commission had in 2008 that come out in the guidance paper. Focus on consumers and not rivals. So we protect consumers, we don't protect competitors, is kind of the general theme that the Commission has. The second theme is, as I tried to suggest before, this idea of anti-competitive foreclosure, which is defined in the guidance paper. And this is kind of the overarching idea about abuse of dominance. So anti-competitive foreclosure is when rivals have limited access and allows the dominant company to increase prices to the detriment of consumers. This is maybe, for me, when I commented on this back in 2005, was the most important part of the guidance paper because it was in line with what I was learning about economics. So from an economic perspective, an abuse of a dominant position is an investment. I abuse my dominance in order to get something. And so if you think about predatory pricing is a two-time strategy. Time one, I cut my prices. That's my investment. I offer discounts and I lose money. Why do I do this? Because I want to remove a rival or discipline a rival in the market. Once the rival has been removed and disciplined and I'm happy, I stop this investment and I recover my costs in time two when I raise prices. And the Commission said every abuse of a dominant position is like that. In one period, I eliminate or foreclose in order for that foreclosure then to allow me to harm consumers afterwards. So the whole purpose of abusing a dominant position is not because I want to be nasty to my rivals, but by being nasty to them, I can then be nasty to my consumers. So if you think about refusal to deal, it's the same. Today, I invest in not renewing a contract so that tomorrow, when you're out of the market, I can increase prices. Loyalty discount is the same. If all the retailers are only dealing with me and you leave the market, I can then increase price. So I think this is perhaps the more fundamental idea that the Commission has in terms of trying to use economic analysis to do this. And the time was right because you probably all heard of the Harvard and the Chicago school debates in the 60s and the 70s and 80s. But there's a third school of thought, which is called the post-Chicago, which kind of emerged in the mid-80s, but only became popular in antitrust enforcement in the US in the mid-1990s, which observed that the Chicago School approach, although correct, was insufficiently dynamic in understanding strategies of companies. And so the post-Chicago School of Economics uses a lot of game theoretical models to say for each action there's a reaction, and so how do firms strategically interact with each other? And this time one, time two stuff is a post-Chicagoan insight. And so it's sort of came out at a time when the economic literature mainstream was moving into this. And in fact, the commissioner at the time was an economist, and he said, I want to write a guidance paper which is in line with mainstream economics. And so he had a lot of influence on this. And then the last thing that I wanted to discuss or introduce is this idea that competition on price is usually a good thing. So we should not invest resources in doing predatory pricing cases or, or discounts, because discounts are good, except when they harm a competitor who is as efficient as the dominant company. And I'll come back to this idea of the as efficient competitor as a standard in a minute, but that's something that the Commission began to introduce in 2008, although it was already present in the case law of the court before. Okay, what does the court say? So the first judgment of the court after the guidance paper is Telier-Sonera, which is a margin squeeze case. And the court tells the Commission, you are wrong. You made a mistake in writing the guidance paper. I'm not going to talk about this in detail, but in the guidance paper, they say refusal to deal and margin squeeze are the same abuse. And the court in Telier-Sonera says, no, they're two different abuses. So that part of the guidance paper has been wrong from day one, because the court says, no, there are two different abuses. But this is not a very interesting case for our purposes, because the court was fighting another battle. It wasn't really fighting the guidance paper. The Lisbon Treaty had just been agreed, so the new treaty on the European Union, the treaty on the functioning of the European Union had just come into force. And what had happened during the negotiation was that the French president at the time didn't like the word competition in the foundational articles in the treaty. He says the aim of the EU should not be to have competition. So he gave a speech and says, what has competition done for Europe? Nothing. We need industrial policy. In order to get the French to agree on the treaty, they removed the concept of competition from the basic elements of the treaty. So if you look at Article 3, it says the Union shall create an internal market, period. Whereas the original version of the treaty was an internal market with free competition. And that was removed at the... Eh? Oh, slower. Sorry. yeah, please tell me, because I can. Yeah. Okay. So the treaty removed this idea of what the draftsman removed the idea of competition in the treaty, and the court in Telier-Sonera reminded the politicians that an internal market includes necessarily free competition. And so the importance of Telier-Sonera is not so much for what it says about the guidance, but more what it says about the importance of competition. And so the court, but it's interesting for our discussion because the court explains that when the treaty speaks about behavior incompatible with the internal market, that means free competition. And so the court says, look, internal market has to include the idea of open markets with free competition, and that's why we have Article 102. And so the importance of Telier-Sonera, of course, it's also for what is a margin squeeze, but also from the purposes of 102, the point the court was trying to make is more to respond to the French rather than to respond to the Commission. Then there were two cases against the Polish monopoly, the postal monopoly in Denmark, 1 and 2. And in Post-Denmark 1, the court accepted the ideas behind the guidance paper, more or less. It did not make reference to it, but it seemed to agree to some of the sentences. But in Post-Denmark 2, they didn't. The facts are very similar in the two cases. In the second one, the Advocate General said, oh, the guidance paper is a very fashionable document, everybody is reading it, but we shouldn't look at it. We should keep to our case law as it was, and we should develop our case law as we, the court, see it, not as the Commission would like us to see it. Because, of course, the court is not there to confirm the Commission's decisions or to confirm the Commission's policy. The court is there to check the legality of that policy. So the Advocate General was not eager to use this document explicitly to develop the law. And in fact, in very few of the cases does the court refer explicitly to the guidance. It's always very implied approval or disapproval. So for a few years, we didn't know what was going on. And then we have Intel. And Intel is the most significant case on competition law until Super League, where the court, in my view, completely accepts the ideas in the guidance. And then we have NL and Unilever. We'll only talk about Unilever today, which, in my view, confirm that the guidance paper is now more or less something the court believes in. And then we have Super League, which I'll come to. So I'm sure everybody knows the Intel case, but if you don't, the facts are very simple. Intel had only one rival chip manufacturer left standing in 1995, American Micro Devices, AMD. And it wanted to get the market by itself. It already had 80% of the market, but it wanted 100. And so it offered discounts to manufacturers of laptops, and it says, if you agree to install my chips exclusively, then you'll get a discount. If you don't, you won't get a discount. And then everybody signs up to this deal. The complaint in this case was in 2000. The commission decision is in 2009. We still have a judgment pending. So the case isn't finished. It's older than my students. Okay, now, what was important about this case is that the commission was writing the decision during the time it was writing the guidance paper. And so it wanted to use this decision to send a signal about what it would do. And so it's a really strange decision, because if you read the first 50 pages, you read the old law. And then for the next 350 pages, the commission said, okay, now you know this behavior is illegal because it's contrary to the old case law. Now we're going to show you that the economic analysis we are going to do in the guidance paper also proves its illegality. So it's a decision that is kind of double. One part, we decide under applying the old case law. One part, we decide applying the new standard, and we show you that the two reach the same result on the facts of this case. All right, so what was the old law? The old law is, as on the slide, exclusivity rebates are abuse of a dominant position. And that was the law in Hoffmann-La Roche in 1979. The Court of Justice had found this pharmaceutical company, Hoffmann-La Roche, that was selling vitamins to manufacturers of products that needed vitamins. And they said quite categorically, if the discount is based on the condition that you buy exclusively from me, that is an abuse of a dominant position, full stop. So it's easy case. The court here, and again, they don't say we are going to change the law, right? They say the approach in Hoffmann-La Roche needs to be further elaborated, or language to that effect. And the first change is that the Hoffmann-La Roche judgment, in their view, creates a presumption of illegality. It just looks anti-competitive, but we cannot yet conclude. So that's step one. So I call it burden shifting, because the burden shifts back and forth. So step one, the burden is on the commission to prove that this is an exclusivity-based discount. If it is, the burden shifts to the defendant, who can then rebut this presumption by giving evidence that the conduct cannot harm rivals. So there is no anti-competitive foreclosure. The discounts benefit the distributors, rivals are still able to enter the market. The defendant can make all sorts of counter arguments, either that there is an efficiency defense, or that there is no foreclosure. If this presumption has been then the commission, if this presumption is successfully rebutted, the burden shifts back to the commission, who then has to test for the anti-competitive effects. If the anti-competitive effects are proven, then the burden shifts back to the defendant, who can say, okay, I agree there are anti-competitive effects, but I can show you some pro-competitive efficiencies, which are bigger than the anti-competitive effects. And then the burden goes back to the commission to evaluate whether these arguments are credible, and whether the negative effects are bigger than the positive, or whether the positive are bigger than the negative. And if the discounts are more positive and negative, it's allowed. If they're more harmful than beneficial, then they're forbidden. None of this is in the previous case law, as far as I can tell. I mean, there is a bit of the efficiency defense in British Airways from 2007, but more or less this is a new standard for discounts. So whereas before you just say, is it discount? Yes. Is it based on exclusivity? Yes. Abuse of a dominant position. Now you have this more refined test. So if you think about this, and you know some US law, you realize this is the rule of reason, which is a burden shifting approach. Plaintiff proves, defendant challenges, plaintiff goes back. Similar approach followed here. So Nicolas Petit wrote a paper saying this is the rule of reason. He didn't understand what the rule of reason was, but he was right in saying that. No, because the rule of reason has changed identity. So in the 1970s, the rule of reason was balancing. The rule of reason is burden shifting. And what's important about this case is the burden of proof moves back and forth. This is foreseen in the guidance paper because the guidance paper expects the commission to do an analysis based on effects, but it also goes beyond the guidance paper by creating the first step as a presumption. So that's not in the guidance paper. So the guidance paper for discount says, we're going to look at all the facts to prove the anti-competitive effects, which is contrary to the case law, which says, no, loyalty discounts are abusive. So the court combines a reform of its case law with the commission's guidance paper. So the first two steps are the court's own invention. Presumption, rebuttable. And if the presumption is rebuttable, then we'll do what the commission says, we'll test for the effects. So this is a fairly fundamental transformation by the Court of Justice, but it shows they agree with the basic idea behind the guidance paper that we need to show some sort of anti-competitive result that is likely to come out of the abuse of a dominant position before we condemn it. Okay, I have a math quiz. No law presentation can do without math. Sorry, I'll explain it to you. But if you want to do some number crunching, now is your chance. So suppose you have a client that buys 100 units of this microchip, and it buys 50 from the dominant company, which I call Domco, for $2 each, and 50 from the rival, and the rival sells cheaper. So observe in this example, the first thing, the dominant company can afford to sell at a higher price than the rival. And this is because the dominant company has a must-have brand. Now, at the moment, if the client needs to satisfy their demand for 100 units, he'll buy 50 from dominant company and 50 from the rival, 50, not 5, leading to a total purchase price of $190. Now, why does the client purchase 50 from the dominant company? Because these are treated as must-have items, or as the commission puts it in the guidance paper, there is a non-contestable share of the market which the dominant company has. So the logic behind the guidance paper on discounts is a firm is dominant for a reason. And it is dominant because some of the goods that it sells must be purchased by the buyer, and there is no alternative to it. So if you think about Intel, most consumers, or many consumers, would not buy a computer if it doesn't say Intel inside. So Intel knew that its original equipment manufacturers would buy a given amount of chips from Intel, no matter what the price was. So there's one part of the market for which there is no competition. And then there's another part of the market, the contestable share, where there can be competition. So in my hypothetical, the 50 units of this client are non-contestable and 50 are contestable. So competition is only in the last 50 units. Now, suppose the dominant company wants to eliminate the rivals and offers a discount, as I say there. If you buy all 100 units from me, I'll give you a 10% discount on the total purchase price. If the client accepts this offer, then his total costs are $180. So he makes a good deal. If he doesn't accept the discount, he pays $190. If he accepts the discount, he pays $10 less. So then the quiz is, what's the price that the rival has to set to persuade the client to stay with him? And the answer is on this slide, he has to sell at $1.60. Notice how much deeper the discount has to be for the rival to sell, because the rival has to offer a discount only on those 50 units, whereas the dominant company can spread the discount across 100. If the rival wants to enter, he can only offer the discount on the basis of the 50. So the guidance paper recognizes this, and they say, look, the bigger the non-contestable share, the more dangerous even a small discount is. If the non-contestable share is 80 units and the rival is competing for 20, I can offer a 0.1% discount and still make it difficult for the rival to compete. So this is the mathematics that underlies the guidance paper on discounts. And then the legal question is, if the rival has to sell at the price of $160 per chip, is this below the dominant company's average variable cost? And if it is, then that's anti-competitive. So you're comparing the actual price that the rival has to set in order to be competitive with the dominant company's costs. And the advantage of the economic logic behind it is that if the dominant company were forced to sell its chips at 160 and that's below its price, then that would be predatory pricing and we would condemn it. So the Commission takes the law on predatory pricing and transfers it to discounts by playing a little bit around with the mathematics. Because in predatory pricing, the assumption is you're competing for the market. In discounts, you're just competing for that slice of the market which is contestable. And so the question is, for the contestable share, is the dominant company pricing at a predatory price? And the advantage of this, from a practical perspective, is that if you're a dominant company, you can self-assess what level of discounts you can give. So I know a lot of economists now who are hired by firms to advise them on their discount schemes. How much of a discount can we award before we go below our variable cost? So it allows for self-assessment, it allows for discounts, but it prevents discounts that are predatory. And so the logic of predatory pricing moves from pure predatory pricing, the AXO case, to this kind of predatory pricing, which is through discounts. And again, if the prices are below cost and economic conditions are such that makes this problematic, then we have an abuse of a dominant position. So these calculations you can find in the guidance paper, and the court in Intel, particularly the general court in 2022, agrees with this approach. So complete okay to the guidance paper after 22 years, but better late than never. Okay, one more point on Intel, which is more general. There's now a lot of discussion in Europe about the as efficient competitor thing. Now, there are two as efficient competitor concepts that exist, and it's important to distinguish between the test and the standard. So the test is what I just explained. Is the price set by the dominant company below marginal cost? If it is, then the assumption is if you are as efficient as the dominant company, you're not able to enter the market because the price is too low. The reason the dominant company can afford to give prices below marginal cost is because it has a lot of revenue, it has revenue from other sources, it has other advantages, it has economies of scale, which the rival doesn't have. The new entrant cannot afford to price at that level. The as efficient competitor standard is a more general concept that asks not whether prices are above or below cost, but whether the conduct of the dominant company is such as to exclude a rival who is as efficient as the dominant firm. So it's not about arithmetic, but it's about understanding whether the conduct can allow the survival of firms as efficient as the dominant company. And in Intel, the court articulates the as efficient competitor standard as a set of circumstances which I've listed on this slide. You look at how dominant the firm is, the share of the market covered by the practice. So one thing about discounts is if I have 1,000 clients and I'm the dominant company and I offer a discount to one client out of 999, then that's not an abuse of a dominant position. Because unless that client is very special, the rival can compete for 999 people in the market. So foreclosure of markets means that the dominant company is offering its discounts to nearly all of its clients so that the rival cannot find an outlet. And the court is sensitive to this and it says, look, we cannot say we are protecting competition unless the dominant company is foreclosing a significant proportion of the market to rivals. If the rival can enter, then there's not a competition concern. And then we need to look at this is about discounts, so the conditions and the arrangements for granting the discounts, the duration and the amount. So duration is maybe an important one. If I give a discount to a client for the month of January, and then I raise my prices for the rest of the year, that's not long enough to cause competitive harm. A discount has to last a significant period of time. So in Intel, the abuse of a dominant position was found to have occurred between, if I remember correctly, 1998 and 2006. So there was a fairly long time during which Intel tried to make life difficult for the new entrant. And then the court says you can also look for a strategy to exclude competitors. So intention can be a part of the elements to think about whether or not you're trying to exclude an as efficient competitor, but that's not necessary. So the standard is a more general assessment model that you look at to ask yourself, is the conduct of the dominant company likely to cause harm to rivals as efficient as the dominant company? But it's not necessarily required to run the test in order to fail the standard. The test is a subset of the standard, but the standard is a more general idea. Is this conduct likely to harm competition by removing rivals as efficient as the dominant company? And the reason the court articulates it in this way is because it wants to send a message that we're not going to protect firms who don't try to compete against the dominant undertaking. You've got to make an effort as a new entrant to try to compete aggressively. So we're not just going to protect you because you exist. And then I want to turn to another judgment, which I think is equally important, but maybe even more, Unilever. Unilever is, you probably know, a big multinational that makes many things from household cleaning to ice cream. And in Italy, there is a very special product and geographical market, which is ice creams that you buy to walk on the beach. So they're very small stores on the beachfront, and people buy the ice cream and then they walk. And that's the relevant product geographical market. Now, a small manufacturer entered the market a few years ago, selling one type of ice lolly. So Unilever sells you about 50 types of ice cream. And if you're a distributor, you even get a refrigerator where you can store them with a label. And this one company had come with this one little ice cream, family-owned company, couldn't scale, but Unilever was scared of the harm to its profit margin that this one small company was causing, which is astonishing, because there was no chance this company could grow. I mean, it could grow if it was bought by another one, but it just didn't have the capacity to scale. So once it reached its 3% of the market, that would be it. But Unilever got so scared that it adopted mafia tactics to enforce an exclusivity clause. It says, if you're a shop and you buy my ice cream, you can buy it. If you buy this guy's company, we'll terminate you. And then they sent inspectors to check that nobody was cheating on the agreement. So it was really carefully policed to protect 1% of its profit margins. So I don't understand what on earth the company was doing, but obviously if your shareholders want you to maximize profits, then this is the kind of stuff you use because it's very cheap. Contract in exchange for exclusivity, no need for a discount, and relevant market is fairly small, policing costs are very low. Now, the case was relatively straightforward, also because the case law of the Court of Justice was very simple. A contract in exchange for exclusivity is an abuse of a dominant position, period. But the party appealed to the National Court, and they said, look, I hired an economist who's very good, and he gave me a study that proves that an as efficient rival could enter even if I have this exclusivity clause. And the first thing you ask yourself is, how can you have an as efficient rival when it's exclusivity? So it's not a discount, so you cannot calculate anything. There's no number here. You buy from me, you get. You don't buy exclusively from me, you don't get my ice cream. So how can you calculate the price that the dominant company is setting? And the way the economist did it is, what are the damages that the small manufacturer, small distributor would have to pay if they terminate the contract with Unilever? And the price of the damages would be the discount that the little company would have to give to the distributor. So if the distributor agrees to terminate the contract with Unilever and they have to pay 100,000 euros in damages, then that's the amount of money that this small entrant should give to this distributor in order to bribe him to sell ice cream made by it. Which was a very strange way of calculating, but it makes complete economic sense to an economist. But the court didn't know what to do with this piece of evidence. The competition authority threw it out and they said, look, exclusivity is anti-competitive because it's exclusivity. But the court felt, but this is the as efficient competitor test, and we just had Intel, which says as efficient competitors matter. What do we do? And so they asked the question, what do we do with this kind of evidence? And it's a very basic question. You have an abuse of a dominant position, which is clear from the case law, but the defendant insists that this conduct cannot harm a rival who is as efficient as the dominant company, which is the new fashion. Which is why the court asks, the Italian court asks the European court this question, because they don't know. And to a certain extent, you can be justified in not knowing, because the old law seems to be changing, and so is the change affecting exclusivity clauses? And the court says yes. And the court says yes for more or less the same reasons as Intel. So the first said, if you have an exclusivity clause, you can presume it's an abuse of a dominant position unless the defendant rebuts the presumption. So if you produce evidence capable of demonstrating the inability to produce restrictive effects, this gives rise to an obligation to the competition authority to examine this evidence. So the same rebuttable presumption you have for discounts based on exclusivity, you now have for exclusivity clauses without the discount. This part of the judgment is interesting because the court phrases this based on the right of the defendant to be heard. So on a procedural right, not a substantive right. They say we cannot have an abuse of a dominant position which cannot be challenged by the defendant. The defendant has a right to challenge the case against it. And if its challenge is using economics to prove that the conduct is not harmful, then that's legitimate evidence, because the purpose of Article 102 is to prohibit conduct which harms consumer welfare. If the defendant has evidence to show that the conduct does not harm consumer welfare, then that evidence has to be admissible. So it's a mix of the purpose of competition law is consumer welfare with procedures. Okay, that bit I think is understandable. The next bit, and I quote directly from the judgment, I'm sorry, I don't have the paragraphs, but the competent competition authority cannot exclude the relevance of an economic study without doing two things. First thing I understand, setting out the reasons why it considers that the study does not contribute to demonstrating that the practice in question were incapable of undermining the effective competition on the relevant market. Okay, basically, if I don't accept the study, I have to give reasons why I don't accept it. I think the study commits some mistakes, the sample is too small, the methodology is wrong, the study does not prove that there is no harm to competition. Okay, so that's normal. You would expect any competition authority, when it receives evidence, to either accept it or reject it, and if rejected, to explain why. Okay. The next sentence I think is a little bit strange. Without giving that undertaking, the dominant company, the opportunity to determine the evidence which could be substituted for that study. So first you have to tell them what's wrong with what they submitted, and then you have to advise them, you're the competition authority. You have to advise the dominant company as to what evidence is needed to survive the attack by that competition authority. Now, if this was a poor litigant going to court or going to an authority, maybe the authority can explain something, right? So you want to complain about your energy prices going up as a consumer. You go to the energy regulator and you say, look, here are my bills. The prices are too high. Maybe the authority can tell you, okay, I don't care about your bills. You have to give me a little bit more explanation as to why you think this is too high a price. I need different kind of evidence. And you want to help the consumer. But Unilever makes more money than the Italian government. So do you really need to advise them on what more they can do to defeat the competition authority if you're the competition authority? I think this is a little bit strange. So I completely understand the fact that the court would like the defendant to challenge the competition authority using economics. And that's the guidance paper. The guidance paper says economics is king. The commission has to make a case based on economics. The defendant should be entitled to defend himself using economics. In this case, the commission can skip the economics because there's a presumption, but it has to engage with the economic arguments of the defendant. But to actually ask the defendant, to ask the competition authority to explain to the defendant what is wrong with their case is a little bit too much. Okay. Now, for me, basically, these two cases go in the same direction. The guidance paper is the law. For price-based abuses, the court confirms what the Commission would like to have achieved, which is you do an economic-based test. Now, one more point maybe I should make, which is obvious. In both Unilever and Intel, the court says the Commission does not have to use economics. They can rely on a presumption. In 100% of the litigated cases, the defendant will bring economic evidence. So although the Commission can rely on the presumption, it never will, because they know the defendant will come up with economics, and so it will also come up with economics. So if you look at all the competition cases on Article 102, the Commission says in one paragraph, yes, we can presume there is an abuse of a dominant position, but here is the economic analysis that proves the existence of an abuse of a dominant position, because they know the economic rebuttal is coming. So the presumption is correct as a matter of law, but as a matter of practice, the competition authority will always try to make its case based on economic analysis. So the presumption is more an illusion than a reality. The computer is low on battery. Do you have a charger?
Oh, isn't it? Oh, right.
I got a warning that, it's not plugged in.
So with tea. Good.
Okay. Right. Okay, let me.
Charging now.
Yes, charging.
Good.
Okay, let me just move briefly to Super League. Okay, very briefly. FIFA and UEFA are international organizations that govern football. So they do two things. They are the regulator in the market upstream, and they organize competition downstream. So they're active in two markets, in the market for regulating football and in the market for organizing football matches. So the World Cup is organized by FIFA, who also regulates the eligibility rules for participating players. Now, if you're a team or a player who is registered with these associations, you have to follow the rules of the association. In 2021, some football clubs in those three countries, Spain, Italy, and the UK, announced a new competition, European Super League, outside of FIFA and UEFA. They didn't get any approval. And FIFA and UEFA responded to say, look, this new league is not compatible with FIFA and UEFA. If you participate as a club, you are excluded from our competition. If you participate as a player, you cannot play for your national team. So it would have an effect both on the teams, but also on the players. And the organizers of the Super League brought a case in the Spanish courts saying FIFA and UEFA are abusing their dominant position. They're also infringing Article 101, and they're also infringing general EU law. And the poor judge in the Madrid court that was faced with this claim with phenomenal amount of lawyers and resources. By the way, UEFA and FIFA are non-profit organizations. Okay, that's all I need to say. Now, this is perhaps one of the most important judgments on competition law ever. So even if you're not interested in football, you have to read this case. And there are two other cases that were issued on the same day, which more or less say the same thing. But first of all, because it's a grand chamber. So it's it's the biggest formation is the full court, but the full court hardly ever meets. So this is one of the biggest formations. So when you have grand chamber, you know the court wants to say something. So Intel 2017 was also grand chamber. So you know there's a signal. We are going to make a move. And the amount of topics that it covers are on the slide. I'm not going to go through them because I'm only going to talk about Article 102. But it's impressive how much the court manages to cover in one judgment about its current opinion on competition law. So I think it's really, really important. But for abuse of dominance, I think there are a number of points that we can take away for today's discussion. So the first is paragraph 129, where the court says an abuse of dominance has two components, a bad act and a harmful effect. So I've transcribed paragraph 129 in bullet points so it's easier to follow. It is necessary to demonstrate first that there are methods other than those which are part of competition on the merits, bad act. And then this bad act, two, has actual or potential effect or restricting that competition, either by excluding as efficient competitors or by hindering the growth on those markets, even if those markets may not be the market where the dominant firm is. Right? So you prevent competition not in the market where you dominate, but in a related market which you might dominate, but you don't. Right? So it's interesting, UEFA and FIFA, they dominate the market for regulation, but they may not dominate the market for for the organization of sports. And I'll come back to why that's relevant in a minute. But I think the first thing that's important is the court accepts that the economics is a vital part of the test. So element 2 is basically the guidance paper. Conduct has to have a harmful effect on the market. The as efficient competitor standard is relevant, but is not necessary in all cases because sometimes you can prove harm in other ways. And it retains the old case law because point 1 about competition on the merits is from the old case law. So it marries the precedents with the new approach. And then one paragraph which I found really nice is 130, where they say, in order to demonstrate these things, you might have different analytical templates depending on the type of conduct at issue. That is to say, for each abuse, you could have a different standard. And I think this is interesting for, just keep it in your mind. All right. So the court always, if you read the judgments of the court as a whole, you will find that they spend 10 paragraphs explaining the general law on Article 102, which are completely irrelevant to the judgment. But they just want to give you a reminder. What is the law on Article 102? But this is interesting because, for example, in this paragraph, it's a little bit different, a reminder, than you get from the other cases. So even though it doesn't look useful for understanding the Champions League case, and it isn't useful for understanding the Super League case, it is interesting as a general framing for how the court thinks about abuse of a dominant position as a structure. Now, if you go to the judgment itself, paragraph 113 is where the reasoning starts. First sentence, the maintenance or development of undistorted competition can be guaranteed only if equality of opportunity is ensured between undertakings. Okay, that's not a new one. Okay, that comes from a judgment in 1991, but it is interesting that the court refers to it in the context of this case, because when the court wrote this in 1991, it was talking about a telephone monopoly. And so if you're a telephone monopoly and the market is open to competition, the incumbent has to offer equal opportunities to new entrants who had never been in the market before, and the incumbent had been in the market for 60 years with state funding. So you have a position of gross inequality between the existing telephone operator and the new entrant, and so you've got to create some equality. And then it has a long paragraph which is about entrusting an undertaking and an economic activity in competition with other undertakings, creating a conflict of interest. So the court explains this: if you're the regulator of a sport and you're also active in the market for creating sporting events, you have a conflict of interest, because if a new person wants to compete with you in the market for sporting events, your temptation is going to be to exclude them because it's your market and you want to make your money there. The Advocate General in one of these football cases makes the point very clearly that it's economically irrational for you not to exclude rivals in the downstream market if you're the regulator. Now, all this paragraph 133 is interesting, but it comes from case law, which has got nothing to do with the UEFA case. It comes from case law on which the legal basis is not Article 102, but it's Article 102 together with Article 106. If you don't know your treaty, this is 106. In the case of public undertakings, or undertakings to which the member state has granted special or exclusive rights, member states shall not enact or maintain in force any measure contrary to the rules in the treaty, in particularly the rules on discrimination and competition law. And since the 70s, the court has created a case law where a state-owned undertaking, or an undertaking to which the state has given an exclusive right, cannot be allowed to abuse its dominant position. And one example is the Motoe case at the bottom of the slide. So Motoe is the Greek organizer of motorsports in Greece, which was given a statutory monopoly by the Greek government to organize and regulate races in Greece. So it was both the organizer of races, but also the regulator of racing. And a rival wanted to have a rally in Greece, and it applied for permission, and it was denied. And the court said the abuse of a dominant position here is the creation by the Greek government of a conflict of interest. So the reason we have liability is not because of any behavior by the defendant, but by the member state, Greece, creating a conflict of interest whereby they assign to the regulator of the sport the power to organize events. And it's that clash of interest which is the abuse of a dominant position. So you have what some writers in the French scholarship called automatic abuse. We don't need the conduct. We just need to look at the design of the market. And so if the Greek law has designed the market whereby the same firm is both the regulator and the market participant, then that is anti-competitive because of the incentives that it creates. The incentive is for the regulator to prefer itself to anybody else. And the court says that those cases can be applied to FIFA, UEFA, because FIFA and UEFA are not state-created bodies. They're private organizations that regulate sport in the public interest, they say, but they're privately organized. They're not set up by legislation. And these requirements are all the more necessary when the undertaking in a dominant position through its conduct places itself in a situation where it is able to deny potentially competing undertakings access to the relevant market. Okay, now this is really interesting because on the facts of the case, it's very straightforward now. We know what's the abuse of a dominant position. It's FIFA being both the regulator and the organizer. That itself is problematic. And that's what paragraph 137 tells us, right? This may be the case when the undertaking has regulatory and review powers and the power to impose sanctions, enabling it to authorize or control that access, and thus a means which is different from those normally available to undertakings which govern competition on the merits. Okay, that's straightforward. But now think about what the court is saying here and look at things in the digital markets, like Google search, app stores, operating system. They are in the same position. They have a conflict of interest. If I own an operating system, I don't want a rival to upload stuff that can then compete with other things I'm doing. If I am Google search and a search engine comes in that competes against me, I want to exclude them by deleting them from my search results. So if you think about the FIFA case from a digital market perspective, you have a gatekeeper who has the power to exclude rivals in markets related to it, and that the court says could be an abuse of a dominant position just because you're both the gatekeeper, the regulator of the entry to the market, and a player in that market itself. And so what do you do if you're a dominant firm and you are so successful that you're present in multiple markets? The court doesn't say it's always an abuse of a dominant position. So in paragraph 152, if you are present in multiple markets and one of the markets in which you're present is necessary for others to enter and compete against you, and you're regulating that access, then you have to have a framework for those powers, for substantive criteria and procedural rules to ensure that the access is transparent, objective, non-discriminatory, proportionate. So if FIFA and UEFA want to exclude a rival Super League, they can do so, provided they have objective criteria, which can be reviewed. So you need to have a procedure for review internally within the process. And the criteria have to be transparent, objective, non-discriminatory, and proportionate. So you can give reasons. I don't want the Super League because it will create too many sporting events and athletes will suffer more injuries. That could be a justification. But then you have to explain why banning the Super League is proportionate to what you're doing. So it doesn't say it's an abuse of a dominant position to exclude the Super League, but it says you have to have a legal procedure whereby there is an internal mechanism by which the Super League can challenge an adverse decision, and a justification is given which follows those criteria. But you can apply these criteria also to Google. Search, for example, take the Google Shopping case, right? So Google Shopping, the case was, Google is a search engine, and people realized that sometimes when you go on the internet, you don't want to search with a general search engine, you want a special search engine. So I want to buy shoes. I want to write sports shoes. Please show me which shop sells search shoes. This is called vertical search. I'm not searching the whole of the web. I want to just search shops. And so Google Shopping didn't like these vertical search engines because consumers were then switching to it and not to its search functions, and was demoting the vertical search engines. So now if you demote, you're basically the regulator who is removing rivals from the market. And do you give access on transparent, objective, non-discriminatory, proportionate criteria? So this could be a general standard you can use for platforms. So I think the case is interesting from that perspective, more than for football, where I think the answer was obvious. Okay, so that's the case law. So one thought you could have is, okay, oh sorry, I'll finish in 2 minutes.
You have 15 minutes.
Oh, okay.
Is it? Am I wrong?
I thought the two. Okay, all right.
No rush.
No rush? Okay. So if you're the commission,
I'm wrong. Sorry, I'm wrong.
yeah, I know you are.
No rush.
Yeah.
If you're the commission and you look at the case law from Intel, Unilever, the commission should say, we have won. We have convinced the court that we are right. The court looks for anti-competitive effects. The court requires the use of economic evidence. The court allows the defendant to bring in economic evidence. What's wrong, right? Why is the commission wanting to reform the law in 2023 when it has been successful in what it wanted to achieve in 2008? So I think that's the puzzle. Now, let's look a little bit at what we know. We don't know very much, okay? Because the commission has been, and there are some things I cannot say because I'm working on this with the commission, so I have a bit of confidentiality, so I'll just rely on what's publicly available. What's publicly available is a document written by 12 officials of DG Competition as to why we are changing the law. Now, if you read that document, you find 3 ideas that are different from the ideas that you find in the guidance paper. So these are the 3 ideas I introduced before. Anti-competitive foreclosure is an investment to harm rivals to allow the dominant company to raise prices. That was the old formula in the guidance paper. In the amendment to the guidance in 2023, the Commission writes what I wrote there. Anti-competitive foreclosure is conduct that adversely impacts the competition structure, which allows the dominant company to have negative influence on price, production, innovation, variety, or quality. One change is the harm, right? So the first one is only about price. The second one now talks about innovation, variety, quality, production. That's just camouflage. Because if you're an economist, you always say price, because it's a waste of words to every time say quality, innovation, production. Price is a proxy, right? It's a brief word to say bad effects on competition, and price goes up is one, but quantity goes down is the other. Innovation goes down. So that's not the point. The point the Commission wants you to focus on is this idea of the competition structure. We want to move away from effects on economic welfare to effects on the competition structure in the market. So competition law should not wait until we have harm to welfare. We need to go a step before and stop conduct when it harms the competitive structure in the market. What that means, nobody knows. But I'll give you one example. Suppose you have a dominant company that has an essential facility. So it has a duty to deal. And it has given access to this essential facility to 6 companies. So now the market has 7 operators, the dominant company and 6 other companies. So suppose it's an airport, and you have to give access to airplanes, right? So one company has access, the owner of the airport, and it gives access to 6 others. And they're all flying to the same destination, right? Same market. So the market now has 7 players. That's pretty good for competition. What happens if player number 8 comes along and says, please give me access? And there is space, okay? There's no capacity constraint. I could give you access. And I say no. Now, if you look at the first test, is this an investment that harms rivals and allows the dominant company to behave anti-competitively? Probably not. There are 7 rivals. If I have one more, okay, a little bit more competition, but it's not really going to harm consumers if number 8 doesn't come in. Assume number 8 competes on the same criteria as everybody else. So it's not a low-cost airline or anything like that, right? It's just you don't increase the number of entrants. But there's one less than there could be, but the economic effect isn't too bad. But of course, by denying access to number 8, I harm the competitive structure. There's one less player than there could be. So if you apply an economic welfare standard, you would not find a refusal to deal with competitor number 8 and abuse of a dominant position, because 7 rivals is good enough. But if you focus on the structure of the market, then if I deny market access to one more player, then that's harm to the structure of the market. And of course, then there's less consumer choice, because there's one less airline. The fact that the consumer doesn't necessarily gain anything from that one more airline is irrelevant. Okay, that's a very simplified example, but I think that's the difference. And the Commission is actually kind of right when it says this, because if you go back to the cases from the 70s and the 80s, that was the original understanding of abuse of a dominant position. The dominant firm has to right to give market access to as many rivals as it can. So the old idea of competition was that everybody should be free to enter the market. And if the dominant company prevents you from entering the market, then the consequences are irrelevant. The harm occurs when that firm cannot enter. So the commission seems to want to go back to the 1970s court, where the court says market access is important, not the effects of market access. So it's an interesting shift from an effects-based analysis to a structure-based analysis from 2009 to 2023. Then in 2009, the guidance paper was all, we don't protect inefficient competitors, we only protect as efficient competitors. And in the amended guidance, the commission says, no, maybe it's a good idea to protect less efficient competitors as well. So we need to give market access to everybody, even competitors less efficient than me. And then the as efficient competitor test was the big discovery in 2009. And in 2023, the commission says this test is optional, we don't need to use it. Whereas if you read 2009, you felt the commission would want to use it as often as possible. And now they say we don't need to use it. Okay, so there's a big change of ideas between the two. So one reason why the commission would like to change could be explained by this. We have a different idea about Article 102 today than we did in 2009. The other way to think about it, this is more sort of realistic, is first of all, we have to correct some mistakes in the guidance paper. So two abuses have not discussed, margin squeeze and refusal to deal. There is lots of case law on both, and the guidance paper does not reflect the case law correctly. So we need to correct some mistakes, but that's easy in a way. It's just technically applying the law and correctly. But two things have come out of the last 20 years of Article 102 enforcement. First, it's really slow to get a result. So in the paper, I try to give you the dates of the commission decision and the Court of Justice judgment. So usually there's 1, 2, 3 years between commission decision and court judgments. Now, if you look at Intel is still going on. Google Shopping, the complaint began in 2009. We are still not satisfied with the remedy, and we still have an appeal. Android was a bit quicker. The complaint came in 2015, the decision came out in 2018, so 3 years from complaint to decision in a complicated market is remarkable, but then they had learned from Google Shopping what the market looked like, but that's still ongoing, and the remedy is still not solved. Lithuanian Rail, if you know this case is about a piece of rail track owned by the Lithuanian Railway Company, and a rival wanted to ride a train through it because it was quicker to ship petrol. The railway company destroyed the track. Now that's an easy abuse, right? You destroy the essential facility. The case started in 2010 and ended in 2023 with all the appeals. Even for a straightforward case, you spend a lot of time, and if you look at Lithuanian Rail, they litigate everything from the definition of the market to the as efficient competitor test. This is destruction of property to prevent a train from moving. The as efficient competitor test is discussed. So the amount of resources that are necessary to run these cases slows the agency down. I did a study last year for the Dutch Competition Authority. We discovered that the agency says, if we do a 102 case, it's so expensive that the cost is a big factor for us to deprioritize. So yes, we have only done 5 abuse of dominance cases since 2000 because they're too expensive. We can't afford to get 50 of our staff of 200 doing 102 because that's what it takes, because the defendant will come in with 3 or 4 economic studies, the market definition will be contested, the abuse will be contested, there will be defenses, and the more procedural rights you give the defendant, the more the defendant will use these procedural rights to defend themselves. These are huge companies. So basically we have a situation where the more economic approach, which is what I've been talking about, leads to costs of enforcement, which are so high for the agency that they cannot run enough cases. And if they do choose a case, it takes a long time to conclude, which leads to the point of ineffectiveness. So, and this I've not talked about, but Google Shopping and Android are cases where the remedy is still contested today. We don't have neutral search. Android is supposed to have a choice screen, which doesn't work. Lithuanian Railway, if the destruction took place in 2008, to get the confirmation that the destruction is abuse of a position in 2023 is hardly going to help the new entrant at the time get a worthwhile remedy. Meta, Facebook, I've not discussed, but again, there you can discuss, maybe we can take it up later. But basically, you have too few 102 cases being brought because they're too expensive. And the remedy that you can get is usually not effective enough to restore consumer welfare in any way. So we don't have deterrence, because deterrence requires you to do a lot of cases. So the probability of getting caught is high. And we don't have desistance, which means firms are not prevented from continuing to abuse their dominant position. So, every year the app developers sign a letter saying Google Shopping is still not solved. So we have a system which is defective. And what is the solution that then is needed is a more aggressive form of Article 102. And I'll just do it quickly. What is fashionable, is, just look at the bottom of the slide, is to ask whether there are certain abuses of a dominant position which we can penalize without doing economics. And the Commission has found that there can be, and this is a set of things called naked restrictions. And it goes back to Intel to discover what these are. So naked restrictions are, in the Intel case, so Intel gave discounts to the equipment manufacturers, but it also paid 3 computer manufacturers to halt or delay the launch of products containing the competitor's chip and to limit the sales channels available to those products. So this is just a bribe. And the Commission said there is no economic sense in this. There's no other justification for this conduct than the harm to competition, and therefore we can condemn without economic analysis. And so there's a hint in the article published by DG Competition that they're going to look for whether there are more naked restraints, so that rather than pursuing cases on the basis of conduct for which we need to prove effects, we just need to prove the existence of bad acts. Now, is that a good idea? I'm not so sure, because it goes totally against the current approach in the case law, which is the defendant has to have a chance of challenging the finding. So if you run a case to say, this conduct is a naked restraint, the court will say, well, we can presume anti-competitive effects with the naked restraint, but you still need to show me that you are able to withstand a rebuttal challenge from the defendant. And then the other point is, just go to the bottom of the slide, you can still have an efficiency defense. So even if it's a naked restraint, what if this restraint is actually benefiting consumers? You've got to give the defendant the opportunity to defend himself. So currently, among people at the Commission, one of the fashionable items in their agenda, and we won't know until the draft guidelines are issued in 2024, is to have a soft law document which identifies naked restraints as a new category of conduct which we can condemn without economic analysis, and so hopefully quicker. And by getting a quicker result, we can get a better remedy. So that's kind of the agenda for the next few months of Commission reform, to get these naked restraints. I'm not sure it's a good idea. As I've tried to show, it runs against the court's case law. So maybe in 20 years, the court may agree there are naked restraints. Okay, so where have we got to? The court has embraced the effects-based approach. What has happened? It's very expensive to bring a 102 case. There's very little private litigation on 102. There's very little public enforcement, except some competition authorities which are very big and have the budget to do these cases. The burden of producing evidence is high. The role of economic expertise is too high. And in a sense, the incentive for the defendant is to use even more economic analysis to make the Commission's case appear weaker and weaker and weaker. And this is strengthened by the fact that the court says any doubt will be resolved in favor of the defendant. And so if the defendant can cause a little bit of question mark in the court's mind, the defendant wins. And so the idea for the Commission to respond to this is to recalibrate a little bit to make the law more enforceable. And so, as I suggested, one of the tactics is to not to focus on the effect on consumers, to protect less efficient competitor, and maybe to go with naked restraints or abuse by object. Whether this works, I don't know, but obviously it's the court that has to respond. So whatever the guidance says will have to then be checked by the court. So, and of course, legal service will have to sign off. So I'm going to stop there. So sorry for taking much longer than I wanted. Thank you.
Thank you so much.
Shall we continue with
Yeah.
the break or?
Or as you want.
Are you okay?
5 minutes, or like we can yeah, okay. So we can reformate the seats.
Yes, so 5 minutes.
5 minutes break, and then we'll meet around, I don't know what time now. around like
On
3:30.
Yeah.
Yeah. Thanks. Very kind.
It's great. Probably, do you
no.
think you would
Yes,
use
here.
the slides again?
No, I won't.
Microphone
Okay.
purpose.
And then that